All right, you're watching Good Morning Nigeria on the network service of NTA, and time to set the tone for our conversation this morning, which is on judiciary, justice, and Nigeria's democracy. Let's now get this background report put together by correspondent Oyemi Ajayi.
The search for justice is a common denominator for not just the common man, but anyone in need. An adage says the court remains the last bastion and hope of the poor, but has this really been the reality? Over time, the Nigerian judicial system has been saddled with the responsibility of formulating, interpreting laws to settle disputes, check illegality, amongst others. Some have opined that the judiciary, which is meant to be independent of other arms of government, especially the executive, isn't totally free from its hold, and many believe the executive oftentimes manipulates justice in its favor. It's been said that the judiciary has been infiltrated, which has made many tag it as where true justice cannot be served on time. This, however, contradicts what democracy indeed stands for. Judiciary has been a major arm of government and a strong force in strengthening the country's democracy. Many have expressed reservations about the justice system in the country, which some blame for low justice delivery. Over time, different measures and policies have been put in place to strengthen the judiciary, but no doubt more still needs to be done. Experts have as well advocated that the judiciary should be exposed to the peculiarities of adjudicating conflicts in the era of digital presence and online identity, which exposes the essence of embracing technology in justice delivery. 24 years down the lane, how well has Nigerian judicial system fared? What more still needs to be done to improve the judicial system? What efforts are being made to ensure real independence of the judiciary? These are some questions begging for answers from guests already seated in the studio.
Thank you very much, Oyemi Ajayi, for that background. Yes, indeed, we have a guest here with us in the studios, and two others are joining us from remote locations, one via Zoom and the other from our Port Harcourt Network Center. Let's welcome Yunus Ustaz Usman, Leonard Senior Advocate of Nigeria, and a regular guest on Good Morning Nigeria.
Good morning, sir.
We're glad to have you.
Good morning.
And also here in Abuja, joining us via Zoom in Abuja. Via Zoom. Is Seratius Umeha. Seratius Umeha is a lawyer and a member of the House of Reps, representing Ezeagu Udi Federal Constituency. Honorable Seratius, we're glad to have you this morning.
Yeah, good morning, gentlemen, and good morning, Nigerians. It's a pleasure to be part of this program.
All right, and we are actually supposed to have another guest from Port Harcourt, Festus Oguche, who is a constitutional lawyer. We have lost contact with him presently, but I'm sure that in due course he will be with us. So, gentlemen, welcome to the program. Yes. Okay. All right. Now we can see the constitutional lawyer that I just informed you about, and that's Festus Oguche, constitutional lawyer, reaching us all the way from Port Harcourt. Good morning, and welcome to the program.
Kieran, good morning, Nigeria. Thank you very much for inviting me.
Well, I was going to ask my colleague Kingsley to start this conversation because he's a lawyer. I'm surrounded by lawyers here, and I'm not comfortable about that. But we're going to kickstart. Let me start with.
Why aren't you comfortable, Kieran? Be comfortable.
Don't worry.
You're protected.
No, exactly. Don't worry. I can take care of myself. Let's start with Festus Oguche, please. We're talking about the Nigerian judiciary. You know more than anybody else, what has been over the years, especially since 1999, in terms of building democracy for this nation. What is your assessment of the performance of the judiciary from 1999 till date, considering that we've had different governments from opposition parties, and today we have a current administration that just started functioning from a particular party to same party. So that is to say, it's not from a party to an opposition. So what do you make of the contribution of this sector of our national life to building the nation?
Very much, Kieran. Whatever view or opinion I express here as subjective, they are all my own personal view. If you are to do an assessment of the judiciary within that period, you look at it within the context of the democratic ambience which it found itself, and the practice of the democratic principles, the extent to which constitutional principles prevail, and the extent to which the leadership abides by these principles and respects the rule of law, the supremacy of the Constitution, the basic principles upon which the democratic system is founded. Where we are still at the experimental stage for some time until we got into full-blown effects of what a real democratic system should be. But what had been happening to the judiciary since then had been issues of suppression and manipulation and undue interference by the political elites in its affairs. It is first of all the fault of the Constitution, because it is not strange anyway that by virtue of the meandering activities of the organs of government, in terms of the separation of theory of powers principle, there's also the issue of the fact that the Constitution allows the political elites to make the appointments to judicial offices, to determine discipline, dismissal, remuneration, and until recently everything concerning the judiciary is tied to the apron strings of the executive. And we have a situation where this interference became so undue that at a point people begin to question on the independence of the judiciary and the autonomy which the Constitution clearly upholds. The issue is not as simple as we are talking, because like I said, you must put it within the context of the ambience the judiciary finds itself, and the fact that we have a desperate political class, and we find the judiciary faulting or not meeting up to its responsibilities in some matters, particularly election petitions and political, and a whole lot of the decisions of the court are even questionable, including the Supreme Court, that people find it difficult to reconcile themselves with it, to the extent that we are well aware that the decision of court will not necessarily have to pander to public expectation, but there are certain issues that should meet that expectation, and the judiciary has failed, I must say, with every bit of equanimity to meet up with these responsibilities.
All right, thank you very much, Chief Festus Oguche, for your opening comments on this very important conversation. I want to come back to the studios here, where the Leonard Silk, Yunus Ustaz Usman is right here with us. Leonard Silk, there are, of course, many ways of approaching the topic today we're discussing, namely judiciary justice and Nigeria's democracy. And happily, Chief Festus Oguche has drawn his own parameters. We might as well also remind ourselves that in 1999, when the Constitution came into effect, the judiciary also had some of the shackles that had held it down during the military era removed by way of ouster clauses, for instance, and the express provisions in Section 6 of the 1999 Constitution. So read together with 4 and 5 will tell us about separation of powers. But the practice in 24 years, as again Festus Oguche has hinted, is such that you have a desperate political class that seeks control over the 3 arms of government, and that the independence and autonomy of the judiciary sometimes has been called into question. What are your thoughts on how we have fared in terms of justice delivery and our democratic journey?
You see, when we want to look at this issue, look at it in the context of Nigeria as a whole, and particularly the three arms of government, the executive, the legislature, and the judiciary. Among these three arms, whether we like it or not, the judiciary is the best, whether you like it or not. I'm an old man. I'm 66. That is no mean feat. If Oguche has his opinion, but let us look at it broadly. If the executive and the legislature had performed 1/4 of the performance of the judiciary to our admiration, would we have been in this situation now? I don't have a brother, I don't have a sister on the bench, but let us be frank. The judiciary has done its best. I'm not saying that it's not possible that you may not have one or two bad eggs. No, it's not an angelic society. But then you won't say because of one bad egg, if you buy a dozen of eggs, and because of one bad one, you say you throw away the 11. No. But I don't think the judiciary has performed poor. No. You may have one or two. In fact, there is no organization, no society without squabble, without grievances and contradictions. And the judiciary is one of them. But the judiciary has not failed. Look, without the judiciary, quote me anywhere, even after my death, Nigeria would have since broken up. Look at how Obasanjo wanted to remove Atiku. Even during the military era, the judiciary kept its toe up, not down. When right from Lakami, they wanted to remove this ouster clause, they say, no, do your own. The constitution guarantees, even under the military, fundamental rights. You know, when somebody does something good, praise him, even if he's your enemy. Then after that, you go back to your fight. But I don't think the judiciary has done that. No, not at all. Look, and in most cases, what really happens, particularly those who do not go to court, sit outside and criticize judgments. And there were some recent judgments that were being criticized, but if you look at them critically, to me, if I were there, that would be my own opinion. You see, when
go ahead, sir.
There's one particular judgment that a particular political party did not do what it was supposed to do, and what the court just said was that your action is wrong. The court never declared anybody a winner. But when they went to town, they said the court declared somebody who did not contest, did not do this. No, it is unfortunate. We should praise our judiciary because of the circumstance under which they work. Yes. It's a very serious, tight circumstance.
Exactly. Okay, go ahead.
Okay, if I may say something. But please, our politicians are the enemies of the judiciary, and you and my own enemy. Let us leave the judiciary alone.
Okay, leave judiciary alone. Good. And as a matter of fact, it's part of what Professor Oguche, told us this morning. So that in some cases, the judiciary is tied to the apron chains of the executive. Right, and we have had in this past election where electoral officers will tell you, I will declare this result, go to court. And so putting about it that to say, look, go there, I will meet you there, even when I know I've done the wrong thing. Believing that perhaps when he gets there, he can change, whatever thing that he may not get, the person may not get justice. That's what it portrays. That's what Nigerians feel. But for some of us who listen to Nigerians and what they are thinking, Oguche also said that the judiciary should not perhaps pander to the public expectation. That is clear. But then when the public sees the truth and we don't get it from the court, what else are we doing? That's part of what we're saying. And I want to bring in a younger lawyer who is now a member of the House of Representatives. So he's going to also participate in lawmaking, you know, and he's like a greenhorn at the National Assembly. But then he's been practicing law for a long time now, because I'm sure he owns a chamber. Now, what is your reading of this profession of yours in a democratic dispensation such as ours, considering our peculiarities in terms of relationship between the three arms of government and what have you? You go to court oftentimes, and I want you to give younger lawyers in this country your own perspective as to what has happened or played out since 1999 till date.
All right, gentlemen. I think I want to agree more with the position of the learned Sikh on the roles the Nigerian judiciary have played and the performance so far. While measuring it, I think the best indices is using the Nigerian context, using the Nigerian peculiarities, using the realities on ground in Nigeria. The truth is that the judiciary has really done well in Nigeria. They have performed above average, considering the desperate environment we have. There are important interventions the Nigerian judiciary has made in recent times that still tend to uphold the judiciary as the last hope of common man. The most recent is the intervention of the judiciary in the issue of the Naira redesign and the effect it had on Nigerians, and so many other recent ones. The truth is that the climate, the atmosphere is not friendly to Nigerian judiciary. We have the desperate political class, just like you rightly mentioned a few minutes ago. This is a situation where somebody will tell you, declare the winner and let them go to court. And he's saying it with every sense of impunity, implying that already he has a way to maneuver his way and to get whatever he wants from the Nigerian courts. So the level of pressure, the level of challenges our judiciary is facing compared to the level of output, you will agree with me that they have really done well. A situation where a judge is a life and liberty, everything depends virtually in the hand of the executive. You look at
Oh, well, there is a freeze there in the Zoom connection to Honorable Serratius. If I understand is back, Serratius?
Yes, I'm back. Yes, you look at the mode of appointment of judges, you look at the mode of removal. This is a system where the executive plays almost more than 75% in the processes of appointment of a judge. And the rule is that he who pays the piper takes the tune. You hardly in the circumstance can operate optimally to the level Nigerians may wish when the system is allowed to remain the way it is. It's also a system where you look at the way and manner judges have been removed in this country. In fact, you look at the way Justice Onohen was removed. You also look at the way Justice Tanko was removed. And in these situations, they are all helpless. It's because of the system, it's because of the society we find ourselves in. It was also in this country that the houses of judges were invaded, their privacy and all you have were trampled upon. And you think that in such situations, you want to get 100% from these people. No, it's not possible. The truth is that we have to go back, look at the Constitution, and carry out fundamental amendments that will help to sustain the independence of the judiciary in the real sense of it, not on papers and not on issues of frivolities, but on the reality, what are the situations on ground. So for me, I give it to the judiciary, they've done well. yes, they may not have, live up to the level of expectations in terms of what we are looking for. But compared to the system, compared to the atmosphere, compared to the environment, they've really given their best. Thank you very much.
All right. Thank you very much, Honorable Sarasha Sumeha, for your comments. We'll come back to you. Let's go back to Chief Festus Oguche in our Port Harcourt Network studios. Chief Festus Oguche, I know you may wish to respond to the views of the other two learned guests, in particular the learned Sheikh here with us in the Abuja studios. But following up from what you said in your initial comments, I was wondering, in terms of advancing the ends of democracy in Nigeria and the role of those whom described as a desperate political class, are we also grappling with ultimately what is the judicial capture that may explain some of the issues that you've talked about and indeed the other guests have talked about?
Very much, Kingsley. In assessing the performance of the judiciary, you're not looking at it from a comparative perspective. It is a special arm of government imbued with the powers of interpreting the law, and the legislative and executive functions cannot come in for analysis, comparative analysis, to assess the performance of the judiciary. Incidentally, we had one of the best judicial systems in Nigeria in the 70s, 80s, even during the military. That Nigerians were virtually running the judiciary in Uganda, in Gambia, in most parts of the Caribbean. And the military treated the judiciary from a respectful distance, from respectful men. In spite of the all-star clauses, we had a whole lot of judicial acrobatism going on, trying to see how these military decrees can be defied and tied into the constitution, even though of the 1963 mood, to ensure that freedom is preserved. But here we are in a constitutional democracy, and we have a judicial system that's so badly suppressed. The two other colleagues of mine who discussed, we are the subject matter really, because they understood that within the context of what the judiciary found itself, they cannot operate in the normal optimal percentage that is required. It's not just the idea of not calling it the proper name it deserves, but saying that, well, they are found within the narrow constrictions of the system they found themselves. But the judiciary has its own self-empowering mechanism, in spite of the constitutional restrictions in terms of appointments, in terms of dismissal, discipline, and all that. We have the NJC, the National Judicial Council, which is built into it constitutionally to protect the judiciary. And I don't see much work coming from their own end when the judiciary is threatened, particularly during the days when the justices and judges, prominent justices and judges who have been hounded and imprisoned and treated like common criminals. When Walter Onogen was removed, the travails of Ayo Salami, and we have cases of complete defiance and disobedience of judgments of courts, that 3 judges last year, or was it this year, had to issue bench warrants against the Inspector General of Police, against the EFCC chairman, and there are an array of judgments that have not been obeyed by the executive. Since 2015, no single judgment of the ECOWAS Community Court of Justice, which has its seat of power here in Nigeria, has been obeyed. I think I happen to have been privileged to join a discussion of some scholars at the prestigious Faculty of Law at the Rivers State University, and they were talking about these judicial essences and how they pertain to the level of the corruption, or how they connect to the corruption index, which the ICPC churned out some few years ago. A pilot survey which was we studied the situation between 2018 and 2020, and how the judiciary was indicted in that as the highest bidder of political corruption, of systemic corruption in Nigeria. The report is still there, and nobody has come to debunk it. So to a large extent, I think we should spade is spade and give it its proper name, and identify the real cause of all these dismantling of our values, national values, insecurity, corruption, lawlessness all over the place, it is traceable to judicial failure. And I say this with every bit of confidence.
All right. I'm really glad it's coming from you, a professional, because we are doing a proper review here to understand why the judiciary, the last hope of the poor, is actually not performing as good as Nigerians would wish. But let me come to this now. When it comes to judiciary, there are individual practices, individual performance. You mentioned even during the military that judiciary was respected, and that has also Chief Oguche also alluded to that as to when the practice was what it's supposed to be. But let me do this. We used to have Ganiyo Yeshola Fawemi. We used to have Rotimi Williams. So these are men who added inestimable value to the practice of law in this country. Justice Tuputa, Mekago, Anthony Anagolo, Nnamani, where we showed in the show anymore, Eurikefe. These are men who were justices highly respected by Nigerians based on judgments, including Alpha Begore. These are men who also worked, during the military. Some of them, perhaps 90s and perhaps early 21st century, from perhaps 2000 to 2005, as this case may be. But I'm talking about the individual who performed creditably in this same judiciary that we're talking about. But today, we have different set of judges that we hear about. A judge will give a judgment in Enugu High Court, and one in Zamfara, another high court, that have equal jurisdiction. We rule against that on the same matter, and it will happen at another point, another end. You see, and these are judges that we're talking about, and this is the practice we're talking about, the corruption we're talking about. Is it the practice that a high court will rule on a matter, and another high court will now rule against that matter, same high court, same jurisdiction, and all that? So the public, people like us who are laymen, who are not learned, I begin to think, if these men are learned, and these men are considering the society where they operate, then why are they, why are justice being punished? I know some of them were punished last time, they were, cautioned and what have you. It never happened in the 80s when we had these names that I read that now. So what is happening to the integrity of the practitioners?
Let me tell you one thing from my few years on earth. I'm very few. The issue is simply this. There's what we call, in Portuguese language, alia putant. You and I may be facing this wall now. You may say this is red. I will say, no, this is brown. The other one, we look at things differently. The mere fact that one judge gives a judgment in Port Harcourt today, another judge turns it upside down, unless we can discover that something had gone underground, does not really mean that both of them are wrong. But in some cases, I agree with you. Like one judgment in Rivers, the man went to Jigawa. But those ones were clear issues of breach of their oath of office. And they were immediately sanctioned. But in most cases, you see, the way the judges work, sometimes you need to be in the system to know how it is. It is not, well, for instance, you go to court and they say it is not your brother that was injured. So you don't have the local standard. The Nigerian will say, somebody is killed, you say, I have no local standard. No, you see, the issue is that ordinarily the man on the street will think you are wrong. But if you allow everybody to go, there will be no end to litigation. Everybody will go. Unfortunately, for instance, I understand that some people now even rush to Okija Shrine and so on, and that they even issue summons now and so on. But these people will know that, you see, this may be temporary relief they may get, because these people are not trained in the art of adjudication, who will not know what is your right to fair hearing, your right to defend, the number of days you should be given to prepare for your defense. So at the end of it, we will still come back to the judiciary. And I tell you, no matter what, the judiciary is still better than the other arms. But I agree totally with Oguche. The real problem we have, and you and I have to solve it, is if our other members of the other two arms of government do not pipe down low, they will destroy this country. They are the ones destroying the judiciary. I tell you one thing, and quote me anywhere, no judge, no matter how corrupt he is, will ask you, give me bribe. No, it's not possible. No judge will ask you, give me bribe.
But do they have surrogates that will looking for it for them? Because they could have some persons who work for them or something.
The issue is that, you see, sometimes we overplay this thing. Somebody may just say, I know this judge. He may know him. He will just go in, come out and smile. Meanwhile, he has not talked to the judge. And he will tell the client, I have done this. But our main problem are particularly the members of the legislative houses. These are the people who are destroying the judiciary. And we tell them, if anything happens to Nigeria, we will hold them personally responsible. Because without them, without the executive, any country can survive. But without the judiciary, no country can survive. So please, I'm not begging them, I'm warning them.
Then I think, the stars. Usman, thank you very much for your comments. Let's return to Honorable Seratius Umeha. Honorable Seratius, stay with us via Zoom. If I can see you there, of course, you're back on the screen. We know there are many dimensions, as it were, to the subject matter that we are discussing today. But earlier I asked Festus Oguche about judicial capture, and in some ways, Senior Advocate Yunus Ustaz has tried to explain how the other arms of government try to corrupt the judiciary. Can the judiciary continue to escalate its performance despite these attempts and pressures that tend to bring about judicial capture and all the other elements that have been cited as examples, including forum shopping?
Yes, there are so many elements that are responsible for the challenges Nigerian judiciary are facing today. Like the learners pointed out, he said that the legislature or legislators and the executive should be held responsible. Well, for me, the way I see it is both the legislatures or the legislators, the executive, and even the judiciary itself are responsible for what is going on in the judicial sector. You could see when the likes of Nemeka go, Ganifa Oemi, and many renowned lawyers and justices during their days, how they hold sway, how they stood their ground, how they were firm, how they resisted intimidations from the Nigerian military, how they resisted so many things that came their way and stood their ground and made mark as far as legal practice and the judicial sector is concerned. But that is not to be talked about of today's situations in the judicial institution. The lawyers are also not helpful in this matter. Many lawyers are not ready to stand their ground. The orientation, the value system, everybody seems to be more interested in amassing wealth. I think you see situations where virtually the senior lawyers are all scampering to, who is richer to compete among themselves on who is richer than the other. Private jails here and there. none of them, well, to a large extent, is really devoting time towards the defense and the sustenance of the independence of the judiciary. So the actors within the judicial institution are also responsible. It is not only the legislators or the executive. I agree to a large extent that the executives are, to a very large extent, the major problem of the Nigerian judiciary. And I've also said that the reason is not far-fetched. The reason is because he who pays the piper takes the tune. If you have a situation where the governor of a state has not less than 80% role in appointing who becomes the Chief Justice of the state, invariably, you should expect that it will be difficult, except if the Chief Judge is a superhuman or one of those special breeds that will stand their ground. You hardly can see situations where he will resist the executive, especially with the pressure. And going and also looking at the security situation in Nigeria, a situation where a judge at any point in time, your security can be compromised, your security can be withdrawn. So many things are responsible. I agree that legislators might be part of the challenges, but at the same time, it's a holistic thing. To me, I think the major problem is corruption. And the desperate political climate. So that is the level of contribution I have towards that. Thank you.
Okay, thank you, Honorable Serratius. I want to bring in Festus Oguche back again into this realm of it. Well, we've tended in the course of this interaction to focus essentially on judicial officers. Let's look at the whole temple of justice administration, where lawyers are also critical players in the temple of justice, or to use the more elegant expression, ministers also in the temple of justice. Have lawyers as a category tried to also examine how well they may be fostering judicial capture or facilitating the erosion of the independence and autonomy of the judiciary by the other arms of government, namely the legislature and the executive branch, and therefore what could be done to push back or at least decelerate the intensity of this interference with the judiciary?
Kinsley, that's a very proper question. Lawyers, like you rightly put it, are ministers in the temple of justice. If you're talking about the judicature, you're talking about the combination of the bench and the bar. They are all in consonance with each other in effecting the nobility of the profession, the sanctity of the courts. It's a responsibility that they all must bear. I think it was one Chief Justice of Nigeria one time who said that the problem of the judiciary essentially lies on the shoulders of the lawyers. He made specific reference to senior lawyers, to the fact that they are the ones that corrupt the system, they are the ones that derail the justice system. And it is very glaring that the quality of jurisprudence, the quality of evaluation, the quality of scholarship in the judicial system has dropped. You take a practical step of looking at the judgment of the Supreme Court of 1972, 73, 74, and reading one of these recent judgments, and you see the comparative distinction in them. But then the issue is also that the judiciary is not doing it on its own. Lawyers are also there, effecting it, running over themselves to capture briefs, particularly election petitions, and seeing how much they can do to get their clients to win as much as possible. So it's a competitive world out there in the practice of the law. And unfortunately, the Nigerian Bar Association that's supposed to checkmate excesses by relying on its own rules of ethics and the Legal Practitioners Act has not been doing very much to that effect. As far as I'm concerned, the Bar Association was totally taciturn when Walter Onogen was unconstitutionally removed, except for some snippets here and there. And we also have a situation where the lawyers themselves are the ones that aid corruption. If you looked at the ICPC report, the pilot report it issued on the corruption index, where it indicted heavily the judiciary and as the highest level of corruption in Nigeria, you'll see that lawyers contribute about 34% in that index in what they do. So there hasn't been much surveillance from the professional body that's charged with the responsibility of ensuring that professionalism is adhered to, and that the whole essence of the nobility of the judiciary, its sanctity, its sacrosanctity is respected. Not much from that angle. Again, I would like to come back to the issue of the judicial capture you asked me earlier, because I seem to have gone over it without inadvertently. It's not judicial capture, it's the constitution that created that ambience for the political elites to take advantage of, interfere unduly in the affairs of the judiciary in a manner that they like, subject to their own whims and caprices. It is not strange to have appointments to judicial offices from the executive. That's the practice in the United States. In some of the states, they are elected positions. But then it is very appropriate, as far as I'm concerned, that constitutional principles, the law must operate within the ambit of the character of the political class we have. Where you find a desperation, then something must be done about it. And the National Assembly has not done anything in terms of reforms in the judicial sector, amending the provisions of the Constitution that allows some of these interferences to ensure that the independence and autonomy of the judiciary is properly guaranteed and grounded in accordance with law. So that's my position. Okay. Thank you very much.
That's your position, but I want you to go further here, just for 1 minute or thereabout. In fact, you raised a number of issues, and does it mean that we have not achieved the independence of the judiciary? We are talking about interferences from the executive and from the legislators and all that. But I'm also thinking about the integrity of the practitioners. You have categorized the lawyers, the categories of lawyers, senior lawyers, and whatever, maybe junior lawyers, as the case may be. But the important thing is this: it takes two to tango. And then people can, my colleague is laughing. People will catch in on those lacunas and begin to delay cases that can be dispensed of in 1 year can last 10 years, because some persons wouldn't like to have justice, and that has happened over the years, and we see it, and we appreciate that. We are saying that the judiciary may be contributing more to its destruction than these other arms that we are talking about. Because one, if a governor appoints a chief judge of a state and the man is not suitable, what does the institutes on that, the MBA, and what do? You sleep? Why don't you in fact go to the extreme of downing tools if you want to make Nigerians understand that you are serious about this judiciary arm of government? Because if you allow the legislators and the executive, they will continue this way, because they are beneficiaries of that. What can be done? Just in a nutshell.
Let's say it there in the studio, Ustaz, well, he happens to be my kinsman. I think he raised quite a lot of issues that answer those your questions and those issues that you've raised. To the extent that I understand, like I said in my salvo, you construe judicial performance from the ambit of from the context of the ambience they find themselves. The judiciary is not contributing to its destruction. it is just being manipulated and rigmarolled about by the political elites to effect its own destruction. And sometimes judicial officers are helpless. They're also helpless in maybe the mood of judicial appointments, to the extent that people who are appointed, they are not so given that privilege by virtue of merit, but on other political considerations that you think might not be very effective and effectual in the dispensation of justice. The other day I saw one professor making critical comments about the recent appointments to some of the high courts. I think it's the high court of the FCT, and how so much constitutions come into bear in a manner that threatens the judiciary itself. So these are political interference factors that tend to bog the judiciary down. And the thing is that the arms of God, the organs of these institutions like the NJC and also the Nigerian Bar Association, which is the association of professionals of which the average judge should have been a member before he becomes appointment, he gets appointed to that position, tends to look the other way. As far as I'm concerned, that activism should start from the Nigerian Bar Association and not necessarily from within the judiciary, because they are helpless. They are like people whose hands are tied. To a large extent, judges cannot make press statements. One particular judge in Kano, I think it's of the Federal High Court, tried to do that. I think it was a reaction from the court itself, and I find that rather bizarre. And judges are so helpless that when they started arresting them and hounding them, the Buhari administration, and treating them like common criminals, it took the intervention of the Court of Appeal in Lagos to remind everybody that that is not how to go about it, that there is a procedure under the Constitution by which you deal with erring judges. And when an application was brought before the CCB, the Conduct Bureau for the suspension of Justice Walter Onoge, it was brought ex parte. And I was wondering why the Court of Appeal in Abuja would come in and think that it's appropriate for that ex parte application to have sailed through and remove a whole Chief Justice of the Federal Republic of Nigeria from office in the manner that they did with Justice Walter Onoge. We are still expecting answers to that. These very serious and bad developments in the system also, I know, by that level of compromise. But it's just the undue interference of the political elites, the undue interference and maybe manipulation, rigmarole, you talked about interlocutory injunctions of senior lawyers. Like I said earlier, Chief Justice of Nigeria has said that the problem of the judiciary lies on the shoulders of the senior lawyers who come perpetrating justice. And if you look at the manner they go about fighting for briefs and fighting for election petitions and all that, and getting into the raid to do whatever they want to do, you see that it is symptomatic of this the deceleration of the judiciary which we are experiencing now.
All right, Chief Festus Oguche, thank you very much. Let's hear here in the studios, Yunus Ustaz Usman, Honorable Seratius Umeha, thanks a lot. Gentlemen, we're going to have to pause for a break, and when we return, we'll get into the concluding parts of this very interesting conversation.
We are Inter-Party Advisory Council, IPAC. We are political parties. We are the pathway to political power. IPAC, in line with its core mandate, is carrying out a peer review mechanism for elected political office holders. Performance of the President of Nigeria, state governors, state and National Assembly members will be assessed comparatively. This will trigger healthy competition amongst our elected politicians to deliver dividends of democracy like good roads, good healthcare delivery system, good schools, full employment, security, and so on. This prestigious program will soon be shown live on television stations across Nigeria. IPAC, deepening and consolidating democracy.
Nigeria means unity.
Nigeria means freedom to me.
Nigeria means greatness to me.
Nigeria is indivisible. There is nothing you can do. We all have to savage it together and learn to love each other. We are indivisible.
As a border, and a leader, I will always preach for peace and unity in this country, because that is the only thing that will give us progress. Though tribes and tongues may differ, in brotherhood we stand, and it is the woman that does that.
Your skill is key to your professional growth in the competitive broadcast media industry. Take advantage of the following programs specially packaged by NTA Television College Jos to upgrade your skill. Marketing in the era of digital broadcast. Date 13th June to 23rd June 2023, 2 weeks. Drama production workshop. Date 3rd July to 21st July 2023, 3 weeks. Intermediate online news reporting skills. Date 24th July to 11th August 2023, 3 weeks. The course fee for the 2-week course is 120,000 naira, while the fee for the 3-week course is 150,000 naira only. Accommodation inclusive. All courses will hold at NTA Television College near Old Government House, Rayfield, Jos. For further inquiries, please call 0803-079-5335 or 0806-980-9807. NTA Television College, Jos, training you to be the best you want to be. Registrar Announcer.
The National Institute of Marketing of Nigeria's annual marketing conference is here, scheduled to take place on the 22nd of June at the Fraser Suite, Abuja. Get ready to learn from great marketing experts as they debate on the role of marketing and ethics in nation building. It's time to dig deeper to understand the role marketing professionals play in the Nigerian market. Join veteran advertising and communications professional, Mr. Lulu Akiomi. He'll be setting the tone at the conference with his key speech, and also members of their academia and leading marketing professionals. Don't miss this chance to be part of this transformational event. Hurry and make reservations. Kindly visit the LinkedIn page that's at NIMN or the website www.nimn.com.ng or email info@nimn.com.ng for more information on how to register. Don't miss out on this opportunity.
The rumor that our nation will break up, even perish. They have even redesigned the maps. Yet we are here. We have stumbled at times, but resilience and diversity have kept us going, and we will keep going. As a citizen, we declare as one unified people, devoted to one unified nation, national cause, that as long as this world exists, Nigeria shall exist.
All right, you're welcome back, and it's still Good Morning Nigeria on the network service of the Nigerian Television Authority. I want to bring in again Learned Senior Advocate Yunus Ustaz Usman. There's an issue that I think we also can take a look at on the part of legal practitioners, those who are at the bar, and then also those who are at the bench, who adjudicate on cases. And my question is this: is the excessive reliance on technicalities by both the bar and the bench impeding effective delivery of justice in our democracy?
Now, I'm sorry, before I answer that, let me clarify one issue that our friend was talking about, this injunction. Injunction used to play a primary role before, but is no longer doing so. For example, under the Electoral Act now, you can't stop anybody from being sworn in if he has won the election. And even if he loses and he has appealed, you can't bring an injunction to stop him until the appeal is decided. So don't fear injunction now.
All right, sir. Apart from election matters, we've had judgments that say so person should not be investigated. So person should not be arrested. Come from the court saying somebody who is allegedly who allegedly may have committed one thing or the other. He said, you go and get injunction from the court to say, don't arrest him, don't investigate him. There are cases that we may mention.
Let me tell you that it is only extremely few judges, extremely few and few bad ones, who now do so. Because the judicial atmosphere now is that you don't prevent the other arms of government from performing their own function, particularly the security agencies. You don't stop them from investigating anybody. And Justice Uwais in Koko Attorney General made that clear. He said, look, it is not our duty to prevent the police or anybody from investigating anybody. That any judge who does so is not qualified to be a judge. That is the standpoint. So any judge who says, don't investigate and so on, and I think if he's reported to the NJC, will have himself to blame. So that is not normal. And then I'm sorry, the issue of the lawyers, particularly with the senior lawyers, the rate at which we fight for briefs is embarrassing. And that makes particularly the politicians to look down upon you and even the judiciary. It is most unfortunate. And you know, when you go to that extent, you have cheapened your practice, you have demeaned your own respect. But they may think of immediate financial gain, but that will not last. But some politicians, I was on a sick bed, a politician called me that I should come and take a brief from my classmate, take over. I said, where I come from, we don't do that. I mean, if you don't stand up to them, they will rubbish all of you. Rubbish the judiciary, rubbish all. And one thing I want them to know is that nobody fends for you, it is only God who does so. This same man who dropped my phone when I returned, send me some money for Salah. I mean, don't allow politicians, particularly politicians, I'm warning them, please don't knock our heads together.
Okay.
Well, I have a question, but I know that maybe First Osoguche may intervene there, and then we'll come back to Leonard Sig, because he's also raised some very important points. First Osoguche, I raised the issue of excessive reliance on technicalities by both the bar and bench as an impediment to the effective delivery of justice in our democracy. What's your thought on this?
I think that issue had been settled long ago after the Kayode panel that investigated judges at that time and the effect of technicalities in the justice delivery system. But the Supreme Court has settled it that technicalities cannot be allowed to defeat the cause of justice. And I'm just surprised that these technicalities still hover around and are being applied in the justice system in matters where they shouldn't even come into play at all. That the practical essence of adjudication should be targeted at the substantive issues, the complaints brought before the court, and not on technicalities of law, whether somebody has a local standing or whether the person that attained a particular level of hours in his sleep, and all those inanities that do not touch on the substantive issues which are before the court. The Supreme Court has settled this long ago. I think it was in the 80s era, 82 or thereabout, is an array of cases that, look, you don't allow technicalities, you look at the substantive issues, look at the substance of the complaint before you. I think there was a reminder, which the reliance was placed very, very well, much on the words of Professor H.R.A. Hart, that you do not subsume justice under political expediency or under any other expediency. Because the justice essence must always be upheld, and you do not throw away a case because maybe there are certain technical issues that the plaintiff or the claimant has not met with. You look at it from the substantive issues of the complaint, whether there's an actual complaint and whether they are adjudicatable by the court, if the court has jurisdiction and the matter is before it by way of the competence of the issues. Then, of course, the court should go into the nitty-gritty of it and find out within swinging pendulum of adjudication where the justice lies.
All right, sir. You well said. But in practice, we see situations where technicalities are used to knock off cases, very good cases. It has happened. Well, you said that it's been settled. You cited a judgment that says it's been settled. But in this country, we have also seen a situation where Supreme Court revisits its own judgment. I don't understand that. The judgment that has been given over the years, and you could return to it and take a different decision, that's a matter for another day. But let's bring in the younger lawyer there with us, Seratius Umeha, member House of Representatives, representing Ezeagu Udi Federal Constituency. You've listened to senior lawyers here with us. We have the Senior Advocate of Nigeria here, and of course the constitutional lawyer with us in Port Harcourt, now, who have both made some comments, which I'd like you to touch on. But more specifically, this is scampering for briefs by Senior Advocates of Nigeria. These are the highest echelon of lawyers in Nigeria. These are people who have perfected in all aspects of law practice, in terms of integrity, in terms of experience, in terms of capacity and capability and training and what have you. Yet they are found wanting simply because they want to make money. Let's call these things clearly the way they are. We are Nigerians. So I am not a lawyer, but I'm representing other persons who are non-learned or whatever, who are not learned, if you like. But what we see play out are things that are questionable. And we keep talking about law reform. I've had that for the past 20 years. Law reform, law reform, law reform. And today, this morning, Mr. Chief Oguche is telling us about that we are at the experimental stage. I can't reconcile that. Just to put all of that into context, please. At the moment. Mr. Meha, can you really hear us? Let's see whether the Zoom connection is effective or has dropped in signal. We seem to have lost him, actually. So let's come back to Senior Advocate of Nigeria. We could return to him as soon as he is reconnected. Senior Advocate of Nigeria, could you address some of these issues that I mentioned?
Yes, particularly the one that actually rings a bell in my head is this issue of Supreme Court setting aside this judgment. You see, hardly would the Supreme Court set aside its former judgment. Hardly, yes. And that is good for stability of the law. In many instances, except where you can prove that you were not given a fair hearing or were not heard. For instance, you filed a motion and then you were not served, but the clerks did not tell them that you were not served and they give judgment. In that case, of course, naturally, they will set it aside on the ground that you ought to have been heard. But apart from those instances, of recent, I've not seen where the Supreme Court has set aside its own judgment.
Which is different, let us say, setting aside is different from a departure from its ratio in the previous case. In terms of yes,
yes,
that's right.
Departure. The departure comes in two different ways. First of all, for example, the Supreme Court is the apex court and a policy court. A court that will aim at justice in essence. Now, as human beings, there is no way they will not make mistakes. It's only God who doesn't make mistakes. If they find out that, look, a particular decision is crippling justice itself, they have the right to depart from it. That is a departure. For example, when we were in law school, there was this case they were using then, this Alakija land case. And everybody was rushing to the Supreme Court to set it aside. They say, this thing will take over all the land titles in Lagos. And then they departed. That is good. And But that one is different from setting aside their own judgment. But most people will not understand this. They say, you did this yesterday and did this today. That one is right, where you think it's going to create injustice. But it's only the Supreme Court that has that power. The Court of Appeal can't do it. The trial courts cannot do that. But the Supreme Court, as a policy court, has the right to do so. And there is nothing wrong with that.
Senior Advocate of Nigeria, with due respect to what I've explained, which is more understandable to lawyers. You said the revisiting, or you said departure, and what I've explained now, is that a particular case, that judgment has been given. Maybe after a while, after some period, a period of time, the Supreme Court could go back to that same case, either do what, if they take any decision that alters the previous one taken, is it right? If there's any, no matter the language applied here, to say, look, we are revising this case for whatever reason,
they are not reopening that case.
No. But they have taken a fresh decision that affected the original one. I'm just thinking. When nobody said departure and all of that. So
let me explain this to you. You see, even in the Lakija case, you are not bringing a motion say set aside Lakija case. No. When you think that in the former one injustice has been created and that injustice will continue at the detriment of attaining justice. If you have another case, you will now want the Supreme Court not to follow their decision in Lakija case
for a fresh case.
Okay. Yes.
That's departure.
You are departing from a previous decision.
Yes.
On a similar matter. So which means that in the previous decision taken, the society didn't fare very, very well with it. I mean, it was injurious to society.
Exactly.
Therefore, they want to go back to it again. But we believe that Supreme Court is the apex court. That whatever decision taken by Supreme Court is sacrosanct.
It is sacrosanct to the extent that it is not aimed at frustrating essence of justice. For instance, if somebody was sent to the gallows and then later on somebody said the conventional statement he made was wrong, will Supreme Court come tomorrow and say because he had been sent to the gallows, we will say all the conventional statements are no longer right? No, you know what? Understand this. First of all, they are human beings, and who have the right to correct the society, correct the system, correct the justice system, and even as individuals, sometimes I hold an opinion today, tomorrow I change. No.
Okay. I understand that.
That's natural.
Do you see that as a lacuna?
But it's a lacuna, of course. I telling me. Ordinary Nigeria will be. I think why I'm happy about this explanation, when Nigerians are beginning to understand it much better.
No, our main problem is that, particularly, the lawyers are so busy trying to amass wealth that we are too alienated from the society in which we live.
All right, sir.
We don't explain things to them.
Time is gone, sir. We'd like to thank you. This is Yunus Ustaz Usman, Senior Advocate of Nigeria, the legal practitioner. We thank you for sharing your experience with us and all the explanations you gave this morning. We appreciate that. Sarasha Sumeha, member, House of Representatives, representing Ziagudi Federal Constituency, Enugu State, who's also a lawyer. We lost him a few minutes ago. The connection could not return. All right, from Port Harcourt we had Festus Oguche, Chief Festus Oguche, a constitutional lawyer. We appreciate your candid contribution this morning. We thank you for that. See you again. All right, a bit of sports before we go. Well, let's get foreign tidbits. That's what we have.
A United States Coast Guard official says rescue crews looking for the submersible vessel that went missing in the Northern Atlantic Ocean are moving assets and focusing their search on an area where undersea noises have been detected. While Captain Jamie Frederick said the authorities still do not know what these noises may be, he stressed that there is still hope to rescue the 5 people on board the sub, which was exploring the wreckage of the Titanic before it lost contact with the ship monitoring it on Sunday. He said a Canadian aircraft first detected the noises on Tuesday and they were also heard on Wednesday. Frederick said remotely operated vehicles operations were relocated in an attempt to explore the origin of the noises, adding that crews are searching in the area where the noises were detected and will continue to do so. The vessel, named Titan, is operated by the US-based company Ocean Gate Expeditions. The passengers on the missing vessel are Pakistani-British businessman Shahzada Dawood and his 19-year-old son Suleiman, British billionaire Hamish Haddon, Paul Henry Gurglet, a 77-year-old French explorer, and Stockton Rush, the founder and CEO of Ocean Gate Expeditions, which is based in the United States. The expedition costs $250,000 per person, and it's a trip that starts in St. John's in the Canadian province of Newfoundland before heading out to the Titanic wreckage site, hundreds of kilometers to the east, as shown by the company's website.
All right, so that's it for us on Good Morning Nigeria today. We thank you for being with us. Join us again tomorrow. We are on same time, 7 o'clock in the morning. Look after yourselves. I'm Kingsley Osadolo.
And I'm Kyrian. I will see you again tomorrow.